Hello and welcome to the big picture. The over 2-decade-old collegium system, which entailed judges appointing brother judges to the high courts and supreme courts, has been replaced. The NDA government notified the National Judicial Appointments Commission, under which a 6-member body headed by the Chief Justice of the Supreme Court will from now on appoint judges and also transfer them. Meanwhile, a petition challenging the validity of the NJAC Act has been referred to a 5-judge constitution bench. A 3-judge bench which referred it to the larger bench, however, refused to stay the act, leading to the government notifying the act yesterday. NJAC has evoked mixed reactions, with many eminent lawyers and jurists opposed to it, while others have welcomed it. The Attorney General of India, in fact, termed the collegium system as illegal. Now that the Appointments Commission has become a reality, we will look at how it is to function and whether it would improve the quality of the judiciary, especially in the context of concerns being expressed about it in the last several years. To discuss this, I have with me Justice B.A. Khan, retired Chief Justice of Jammu and Kashmir High Court, K.N. Bhatt, Senior Advocate, Supreme Court, Neeraj Kumar, Assistant Professor at the National Law University, Delhi, and Satya Prakash, Legal Editor, Hindustan Times. Welcome to all of you. Justice Khan, this whole move has been, we have been discussing this for the last several years, for more than at least a decade now. And now that it has finally become a reality, we'll wait, as far as the petition before the Supreme Court is concerned, we'll keep it aside for a moment. You think that this was the best option available at this point of time?
See, Girish, we have been always maintaining that a change was needed. For several reasons. Because the collegium system, which, as you referred, was a usurpation of power of sorts by the Supreme Court, I should say, in breach of the relevant provisions of the Constitution providing for appointment of judges. See, that collegium system, it was expected because the whole thing was to be done by the judges themselves. And with judges, you attach all types of impartiality, integrity, and all that stuff. And the expectation was that that collegium system will come up with a selection on merit and so on and so forth. But in the course of time, what was experienced was worse than what was happening earlier.
Before the collegium system?
Yeah, before the collegium, when the appointment of judges was in the hands of the executive. Right. And all sorts of allegations of favoritism, of deals, of this and that, and which resulted in creating an impression that recruitment to the higher judiciary is by people who don't deserve it, undeserving people. So a change was needed. Now, when change was debated, and you conducted so many debates on it, and the debates were meant to provide for a better forum or a better mechanism which could perhaps deal with the defects which had been found in the collegium system. And every expectation was that the systems in other countries like South Africa, like England, in UK you have a system, a very broad-based commission comprising of diverse sections of society, academics, so on and so forth, would be put in place. And the selection would then happen on merit, ability, and so on and so forth. Now, that didn't happen. And if you remember, at one stage I said it is old wine in new bottles. You have 2 people added to it called eminent people. Those eminent people are to be selected by
a committee,
Prime Minister and Chief Justice and the leader of opposition and so on and so forth. And would those 2 people make any difference on the scene? Ordinarily not. For the simple reason that when you have Chief Justice of India and 2 more judges sitting on the same panel in a 6-judge, six-member panel, where you have Law Minister and those 2 eminent people. Now, those 2 eminent people are expected to be from the legal fraternity only. Now, let us say, assume name A is the eminent man. I would name Mr. Bhatt at this stage as a participant. Would he afford to go against a selection agreed upon by the 3 Supreme Court judges is the question. Number one. Number two, even if he is a government sponsored, as is the apprehension and as is the petition before the Supreme Court, it is going to erode the judiciary's independence and all that stuff. What would be his overriding power of that?
Of those two members.
3, very important. What is his way of determining that he is the best or who is the best? See, there is a candidate from Assam or Kashmir. And Mr. A, an eminent Supreme Court advocate, is on the panel. How does he know about that candidate? Therefore, unless this system, we have to give it a chance. See, we can't be just now concluding that no, it's no good.
It won't work.
Unless we have 2 things in place. One, a criteria for selection, as you have in any appointment. If you have an appointment of a section officer, you have a criteria. Unless you have a criteria...
Why do you think there is no criteria?
No, so far it's not laid down. It only says in general terms merit and ability. It has to be specified as you have in the UK. In UK,
when the rules are formed, maybe
yes, in regulations, yeah, it may be expected. Number 2, unless you have, the commission has its own investigating agency or source or anything, otherwise it will be again dependent on this IB and RA and this and that and this and that, where you get wrong reports and all that stuff. It is not possible to determine the antecedents of a candidate and the merit of the candidate. And we go back to the square one, same thing. For High Court judge, the recommendation is to emanate again from the Chief Justice.
High Court Chief Justice, also the Governor and the State Chief Ministers also are expected to be...
Commission would be referring to them.
They will be consulted.
There is a little change. Commission would be referring to them. Earlier, what they would do was that Chief Justice of the High Court would make a recommendation and the Chief Minister would sit on it and then insist that unless my man is there, the recommendation will not go ahead. There is a little change. The Commission is making a reference to him for consultation. He will not be bargaining with the Commission in that case. I find a change in that.
Okay. So you raised certainly important. Mr. Bhatt, this is a commission. It's now become a reality. A whole lot of doubts and concerns are being raised. A very eminent person, a former law minister like Mr. Ram Jethmalani says that this is going to be a disaster because he thinks that one important issue he has raised, that a litigant be appointing judges because government are the biggest litigants in the judiciary, in the higher judiciary. So they are themselves appointing the judges. That is one of the points raised.
See, one of the fundamental things about which everybody is agreed is that the collegium system was bad.
Has failed.
It has failed, and it was invented, or rather fabricated, for meeting a temporary situation then prevailing. But it has not worked satisfactorily for whatever reason. But the question is whether the remedy suggested is worse than the disease. That is the reason, because of the provision that the constitutional amendment merely says that there shall be a judicial appointments commission, naming the people, etc. Everything, every detail is to be done in an act, that is the Judicial Commission Appointment Act, or something that is the one which is also been notified.
National Judicial Appointments Commission Act.
This act can be amended by a simple majority by the Parliament or even by an ordinance. The act stands today, for example, one of the provisions is that if 2 members of the commission oppose an appointment,
vetoes,
they have the appointment veto power. And this is provided in the act. It can be made as 1 or it can be made as a unanimous. Because the position is that look, I'm not saying that look, anybody will commit a harakiri in terms of the constitutional responsibility. But what is happening is all these provisions are contained in an ordinary law.
So what are you trying to say? It should have been a constitutional amendment?
It should have been a part of the Constitution. For example, you see some of the basic provisions, like for example, you see the Public Service Commission. It has got greater autonomy today than the National Judicial Commission. It has got particularly in one aspect, the entire office and the members of the staff, etc., are part of the department of the government. And this National Judicial Commission will not even be having a car at its disposal unless it is given by the Law Ministry. And this is the position which will ultimately, whether it will subserve the independence of the judiciary, that is the question, because the change was needed. And it is not even about the 4 members and 2 members and 1 member, etc., because I don't expect that all judges, 3 judges sitting together will decide one way. Justice Khan knows that they very often agree to disagree. So there will be many cases where, because whether the law minister or the eminent person have, in what pattern they will be voting, is very difficult to see.
Right.
The eminent person can be appointed only for 1 term.
That's for 3 years.
For 3 years. So they don't have to be grateful to the government which has appointed them beyond a point.
Exactly.
So the question today is I must disclose one thing. Actually, I ought to have disclosed it earlier. Tomorrow the matter is coming up before the Supreme Court.
Right.
I am appearing for one of the parties challenging the act.
Okay.
Okay, that is something which I wanted to tell you.
Okay, that is an honest disclaimer. That shouldn't come in the way of you saying what you need to say.
But this is a public law aspect where one need not be personal about it.
Absolutely.
We take a view at this because none of us is...
So you are saying that it should have been a constitutional amendment, Justice Khan? You don't seem to agree?
No, not at all. See, in Constitution, you don't provide detail about...
No, it should not have. It need not have been. It need not have had that kind of a constitutional backing. What Mr. Bhatt is saying.
No. See what has happened is
even the Scheduled Caste Commission. These are the commissions. They have got a long enough chapter.
Which ensures. You are saying that it would have ensured more independence.
Some fundamentals are put there because this.
Not necessarily because Constitution amendment.
Now everything is by regulation. The regulation. One aspect, one more. Everything is governed by the regulation. Qualifications are decided by the regulation. Conditions of service, whether...
They are not in the Act.
They are all, no, Act and subordinate legislation. They are not part of the Constitution. The position will be, therefore, these regulations can be amended by the Parliament, though it is made by the Commission.
By a simple majority.
By a simple majority.
Yes,
Mr. Baba, I don't subscribe to the view. Constitutional provision is not going to provide for everything. Then the act made by the Parliament provides for a procedure, good enough. Now, when Mr. Bhatt is talking of regulation is not referring to the basic qualification of eligibility, which are already provided in the Constitution.
Only one. Sorry, Mr. Khan. It is a 10 years or an eminent jurist. Apart from that qualification...
No, you're talking of the committee.
No.
You're talking of the persons who are going
to be appointed.
As a judge.
As a judge. Okay. Now, for example, somebody can add by a regulation that unless he has got a minimum of 8 years service, he shall not be taken.
Beyond that, a regulation will provide a procedure which can deal with some kind of a criteria. For example, a regulation may provide for an interview. So what's wrong with that? So it is not everything to be provided in the Constitution, nor is this apprehension well placed that by providing everything in a regulation or by providing a procedure and a regulation, independence of judiciary is going to be eroded.
You don't think so? Okay. Let me get Neeraj Kumar on this. Mr. Neeraj Kumar, one of the arguments by people who are critical of this Appointments Commission is that you have a situation where the government appointees are there, the law minister is there, two of the appointees are going to be political appointees essentially, even though Supreme Court Chief Justice is there in that committee. So a litigant is appointing the judges, so it is not the best thing to happen. And somebody like Mr. Ram Jethmani has suggested that it should have been this kind of an appointment commission should have people from the bar and also from the academic field.
Uh, my view on this is that what I find that most of the people at this point of time they are making an Cassandra's outcry that everything is going to fail and all this. My issue is that in any constitutional appointment where a person is holding a constitutional office, I firmly believe that there has to be a democratic participation, which was seriously lagging in the old arrangement which came through judicial interpretation through series of judges cases and primarily the advisory opinion known as third judges case. So I don't find that it is against the basic constitutional philosophy, because prior to the third judges case it was being appointed by the people who were having political background or part and parcel of executive. So you cannot say that it was something which was written in the constitution. It came as a process of judicial interpretation which has been criticized everywhere. And if it is all about that something will fail and something has actually failed, I will like to take a risk on the other side that let us give something a chance which may or may not fail. Secondly, if you'll see the primacy part and all this, I don't see any significant change because Chief Justice of India has to be appointed by seniority under the new proposition also. Secondly, what you find is this, that with respect to consultative processes also, if you'll see the third judge's case also, let us go by that only, it says that primacy of Chief Justice of India in appointment of judges is ensured in ensuring that nobody is appointed if he doesn't agree. So similarly here also, if majority of the judges are not agreeing, nobody can be appointed. In this case, two dissent is only required. So I don't see that any person can be appointed without having a judicial backing with them. So I don't see any problem with respect to existing system and very marked differences which is going to arise if your new system is being brought into existence. Rather, if you'll see that this was a system which is almost unheard anywhere, that people are supposed to appoint themselves, and that has been a primary criticism. And if you'll see otherwise also, the primary concern has been judicial independence, nothing else. And judicial independence as supposed to be ensured or protected as understood in various judgment has been basically taken care of in the new amendment and the subsequent and the laws also. Because you'll see that in case of appointment of High Court judges also, the Commission is supposed to take into its fold the view of
the High Court
Chief Justice of the High Court, and he in turn is supposed to consult
two senior judges.
Yeah, he is supposed to take into consideration the view of two senior most judges. So far as the substantive provisions are considered, I don't see any marked difference from the third judge's case, that is the advisory opinion. Except for the fact that you just think that just because of the fact that formally politician has come into being, has been formally made a part and parcel of that itself is problematic.
Okay.
Thirdly, something which is not being talked about.
Please continue.
That will see that amongst the two eminent people who are supposed to be appointed, one of them who is getting appointed must belong to scheduled caste, scheduled tribes,
yes,
minority, or maybe women. So that is a wonderful way to give effect to the community voices, which has been a prime concern in the appointment of judges. You cannot create an ivory tower for the purposes of appointment of to an office which is a constitutional office.
Right.
So that is something which is a very wonderful and beautiful thing which has been done.
Okay. Satyaprakash? Government went ahead and... thank you. Okay, I'll come back to you, Neeraj. Government has gone ahead and notified this, despite the fact that there's this petition pending in the Supreme Court. Why do you think they did it?
No, that is because the Supreme Court itself refused to stay
the act.
But and then the Attorney General made a statement that we'll notify it at the earliest. But what has happened is nobody is talking about it. Hours or maybe minutes before this act was notified, both the Constitutional Amendment and the NJAC Act, there were 27 appointments to 6 or 7 high courts under the collegium system.
Happened.
Hours or maybe minutes after that, by the evening, you got the notification. And there were 2 transfers also in high courts. And
so 27 judges were appointed yesterday?
Yesterday. 27 to...
So this was the last of the collegium system, sir?
Last set of appointments by the collegium system.
And that cannot be overruled?
No.
Okay.
Because thereafter the notification. So one. Second is, everybody has agreed that the collegium system had failed. Why it failed and what was the worst criticism of the collegium system? That was the entire system is opaque. Right from the day a name is recommended for judgeship until the time the warrant is issued, the warrant of appointment, nobody would know who is the person, why he or she is being appointed, nothing. Finally, you know that somebody has been appointed as a judge. So the worst criticism was that this system is opaque. Unfortunately, under the new system also, you don't have any provision that ensures that it is transparent. So that is the worst criticism of the new system. But having said that, I'll give some time to the new system. Why? Because for the first time, the judges, after three judges cases and the last one reference case, the judiciary had rather usurped the power of appointment of judges.
Right.
And making India one of the, perhaps the only country where judges appointed judges. So this was, the entire system was extra-constitutional system, may not be unconstitutional, but it was certainly extra-constitutional.
Attorney General called it illegal, actually.
No, he might have called it, I would not call it illegal or unconstitutional, it was certainly extra-constitutional. But the new system, it is, first, it is still opaque. Second, the good part is, it ensures better representation of various sections of the government not necessarily, I would rather say a state. Now the executive also has a say in the appointment. Civil society has say in the appointment in terms, because
those two eminent people
and,
are supposed to.
as Professor Neeraj has pointed out, that there are now there is
one of them is reserved for
yeah. So this way it's rather broad-based. The only negative point is that the entire system remains opaque.
Okay.
If it can be made transparent.
No, that's a very important point which you have made, Justice Khan. See, ultimately, why are we doing this? Why is this new system being brought into place? Collegium system has been. It's quite interesting that Satyaprakash has revealed that 27 judges were appointed yesterday as a last gift to this country. The collegium system has appointed 27 judges. Very interesting. But ultimately, why is the system being changed? To ensure that the quality of the judiciary improves.
1 minute.
Yes.
That process was on. It is not that because the bill
it was not that.
It is not a halt and proceed situation, because it was going on. We need not attribute any motives.
No, we're not attributing motives, but
because the 27 judges, many of them were ad hoc judges who have been made permanent.
Okay.
All these additional judges.
No, no. As far as the quality of the judiciary is concerned, whether the system is going to improve the quality of judiciary, that is the essential question.
We hope so, Girish. And what Satya raised, the point is a very important point, because this whole thing was shrouded in a mystery.
Yes.
This collegium thing. And the 5 judges sting, God knows what they were doing. And one day we would hear that one gentleman has become a judge of the Supreme Court, of the High Court, and so on and so forth. Nobody knew about it. Nobody knew.
No, but his point which has been raised.
What I'm saying. What I'm saying.
Yes.
If this act doesn't provide for that, I hope that the regulations may take care of that by saying, for example, if a criteria is provided, that the list of the candidates would be put in the public domain on a website.
This has been the demand of several people.
It will take care of that, so that people know who is the candidate. If somebody has an objection, otherwise also you have lots of complaints coming against a candidate the moment it is known that he is being recommended.
It is known, it is not known. I mean, moment it is rumored.
Otherwise
it is rumored.
But there is a great need of making a provision for making this commission proceedings transparent. Unless you have that, it will be again back to square one.
You expect any such transparency?
And one good thing,
Yes.
one good thing which I find in this, because see, we had a very big problem in hand of the vacancies remaining there for years on,
yes,
because of disagreement between the Chief Justice and the Chief Ministers and the Centre and the states and so on and so forth. Now, in this new thing, we find that as like any selection, like Public Service Commission, the central government is going to send these vacancies to the Commission, and there are time limitations given in that. And within those time limitations, those vacancies, if get filled, we will have a major problem having been tackled of the judge population ratio, as we say.
So you expect that's a positive thing?
Yes, yes. For example, 500 vacancies in the high courts, if those get filled, we will have a major change.
Okay, Mr. Bhatt.
See, I agree that there was no transparency. And I also agree that there is no transparency now.
In the present act
in
also.
The present provision, nowhere.
Yes.
The only way the transparency could be assured or ensured, along with the candidate's own future, because the moment somebody's rumor floats that he is about to become a high court judge, his practice drops. And after some time, because I myself know that as there was a rumor that I was about to be appointed additional Solicitor General, and for 3 months nothing happened except my briefs came down enormously. So these are all the professional hazards. The one thing which is most needed is there must be a mechanism for collecting and making a data bank
of qualified people.
Qualified people, possible appointees. And at that stage, that is not a commission, but some other agency subordinate to it, which will invite objection. These are the names which have got anybody else. No anonymous letter will be taken. If somebody has something, can be done, etc. At the end of it, there is a data is published, and within a specified time limit, they must be either accepted or rejected, so that they can have their own way. Today, even in the present one, it is all left to the mercy of the executive government. The transparency is there for the executive government, because they know who are the candidates, they know who are this one, nothing more than that. That is the reason why.
But you think that will not prevail now?
No,
that situation can still prevail?
It is left to the mercy of the government as it was before 93.
Right.
That's all that I am telling. There is nothing more than that. I am not saying that it is wrong. Actually, some of our most brilliant judges
have been appointed.
Were appointed before 93.
Okay.
That is
Neeraj Kumar, so do you expect this transparent? Do you think that this kind of transparency should be there before appointment of judges?
Yeah, of course, there should be transparency, and we must take cue from UK on that. That they have made the things very transparent, and of course there was something which was doing around in otherwise private circles, that it is as good as judges are getting appointed in golf courses. So nobody knew that who is being considered, and once you suggested that it is a judicial process, so that's why the possibility of review and all this was also curtailed down. So of course sometimes what actually used to happen, that you just have to flare up some rumor to actually raise serious doubts about the people who otherwise have not done anything wrong.
Absolutely.
Or otherwise
that is
utmost integrity, but because of the fact. Yeah.
Okay. Yeah. Okay. Satyaprakash, very quickly.
So because you don't know who are those people who are their conditions.
Neeraj, we are completely running out of time. Sorry, Neeraj, we are running out of time. Satyaprakash.
Yeah.
So this transparency can work either way. Very quickly.
No, not either way.
No, it can transparent in the sense you put up the names of the candidates, and then lot of complaints may come and create problems.
Write complaints, you need not make it public.
Okay.
But the committee should have, this college, this NJAC should have the benefit of public reactions to whatever names or whatever. If you put up the names on the website and people are given opportunity to send their reactions or whatever information they have, then you will avoid circumstances where people have been appointed without knowing.
And then you come to know
certain cases pending in this.
Yeah. Very quickly, last word, sir. So you expect this to, you would like to give this a chance to see and work, to see whether it works.
Girish, very much. See, the success and failure of every system depends on the people who work it.
Absolutely. So on that note, I think
this system is to be given a chance.
Okay.
And in all fairness, I am not contributing again to what Mr. Bhatt says, that at the mercy of government, everything. Nothing is at the mercy of the government. Procedures are the same.
Okay.
Please give it a chance.
Okay.
There are some good points. Allow it to function for some time and then see.
Okay. Very quickly.
It's too costly an experiment to allow it to function for some time.
Okay.
And
So-
but one thing, public hearing in the United States, the Senate Judicial Committee hearing, Justice Clarence Thomas was examined for 13 hours.
Exactly. So, you know, we don't have that kind of system, unfortunately, in this country. But as you have witnessed, there is difference of opinion. People are divided. The judiciary is divided. The legal system itself is divided over this. We'll wait and watch what happens. Ultimately, the Supreme Court, which will be hearing this case, will decide whether the validity of it or not. Thanks to all my guests. Please keep watching. We'll come back with another issue, big picture, same time tomorrow.